So Justice Helene Namisi reminded us that parental responsibility is not punishment, it's not leverage, and it's not a wealth transfer. It's about children, not winning, okay? Ladies and gentlemen, boys and girls, welcome to another episode of Katiba na Chai, the show where we take Kenyan court decisions, strip away the legal intimidation, we add context, culture, and just enough humor, and ask one simple question. What does the law actually mean for our everyday lives? Now, before we begin, one important reminder. This is a children's case. And in children's cases, we don't use names. That's not because we care about protecting adults from embarrassment. No. This is about protecting children from some weirdos on the internet because they might grow up being searchable. Okay? So today we are not here for gossip. We're here for the law and logic. And a High Court decision that quietly wrote how Kenyan parents should think about separation and the costs after. This case was decided by Justice Helene R. Namisi of the High Court. And it answers one very Kenyan question. When we say shared parental responsibility, do we mean partnership? Or do we mean one parent pays or the other parent supervises? Now, our story begins in 2018. Two people get married under Christian rites. They live together in Kilimani, Nairobi. They had two children, and both were under 6 years old. And now, the part that makes every Kenyan auntie emotional, both parents were doctors. Not interns, not registrars, consultants. See, the father is a consultant ophthalmologist. I had to practice before, and a university lecturer. A man whose entire career is about helping people see clearly. The mom is a consultant anesthesiologist. I know I struggled as well. Employed by a county government, right? So she was a doctor whose job is to put people to sleep safely and wake them up again after surgery. Now, if Kenyan parents were building a marriage using specifications, this is the final product. In ndio nataka. One doctor helps you see, another one helps you rest. This is it, two consultants, nearly identical salaries, a church wedding, Kilimani address. Oh my God, this is the couple relatives point at and say, you see, unaona, focus, education, God. And that's what makes this case uncomfortable. Because, if this couple could not separate peacefully, then maybe education does not fix relationships. Maybe education just gives our arguments better vocabulary, Yeah, you're an ophthalmologist. Yeah, and I'm an anesthesiologist. Anyway, in November 2021, the marriage collapses. While the father was at work, the mother left the matrimonial home with the children. She's relocated to Ongata Rongai, withdrew one child from school, and communication even stopped. Now, the father says he had no notice about that move. He reported the children were missing, and here's where the irony hits. This man is a consultant ophthalmologist, a specialist in vision. And yet, when the marriage ended, he could not see his own children. He had to rely on CCTV footage to trace where they had gone. Guys, there's something painfully modern about that. A man who's been trained for years to diagnose eyesight problems needing surveillance cameras to locate his family. All I'm saying is even specialists have blind spots. Now, the mother, on the other hand, says she left to protect herself and the children from psychological and emotional harm. Now, the court does not decide who is lying in this case. Instead, the court decides something more useful. So now, what happens after that trust has collapsed? Now, let's talk about the relocation first of all, because Kilimani to Rongai is not just distance. It's time, it's fuel, it's traffic, it's a lifestyle change. You see, in Kenya, people, how we joke that Rongai is another country? To me, it's a different time zone, it's a different fuel economy. We don't pay the same price for fuel, So when a child is moved from from Kilimani to Rongai, that's not neutral. This is distance with intention, And the professional irony is too neat as well, because the mother is a consultant anesthesiologist, but her job is to put people to sleep for carefully measured periods, And some of that expertise was applied to a daily school commute for the kids for one kid from Kilimani to Rongai. Now that's not a school run. That is a long-acting sedation session. By the time you reach Rongai, I mean, even your dreams have changed, man. You know, they've changed counties, and this distance is about to become very, very expensive. Because in January 2022, the father moves to the children's court. And what followed is familiar to many Kenyan parents who have tried to go to court around children. You're given access orders, contempt applications, police enforcement, WhatsApp messages that you keep getting in the middle of the night that start with, as per the court order. So basically, the magistrate's court tried to stabilize the situation. It ordered joint legal custody. So physical custody to the mother, meaning the kids would live with the mom, and structured access to the father. That means occasionally the father would have access to them. Then came maintenance. See, the father was ordered to pay full school fees, school-related expenses, school transport costs, and clothing, using a quarterly list prepared by the mom. So the mom would prepare a list every quarter to know hinguo, which meant that parenting had now entered the same cycle as VAT returns, you know. Now, at first, the father paid transport. Then he stopped. Why? Because transport was being charged at school bus rates, even when the children were sometimes being driven privately. In other words, he was being asked to pay for a bus that may not even have existed. At this point, co-parenting officially became accounting. They started deciding each other execution proceedings, and by 2024, no one was happy, neither the dad or the mom. So the father appealed, and on his appeal, he relied on Article 53, 1E of the Constitution, which says, a child has the right to parental care and protection, including equal responsibility of the mother and the father. He argued that parental responsibility was being used as punishment here, that both parents had almost identical salaries, that transport costs exploded because of a relocation. He opposed, and that those quarterly clothing lists that were being sent had turned parenting into supervision. But the mom was like, okay, you think so? She then filed a cross appeal herself. She argued that the children were of tender years, that the father in fact should have reduced access to the kids, and that when the children were staying with the dad, they were left with strangers. And this sounds serious. I mean, until the record clarifies that the so-called strangers were, one, his niece, meaning their cousin, a university student, that is, the niece was a university student, and a close in-law. I mean, in African households, is that really a stranger? Isn't that how civilization just survived? You know? Now, Justice Helene Namisi grounded the judgment in law. She cited Article 53(2) of the Constitution, which states that the best interests of the child are of paramount importance in every matter concerning the child. Then again, she also cited Article 53(1)(e), which provides that every child has the right to equal parental responsibility. Then she enforced it with Section 32 of the Children's Act of 2022. After that, she addressed the heart of the problem. Shared parental responsibility does not mean a mathematical 50-50 split. It means equitable contribution proportionate to means and circumstances. The court noted that both parents were high-earning professionals, and the income difference was almost negligible. And yet, the father was carrying almost all direct financial costs. Then came the finding that made this case famous. Ordering payment of transport at school bus rates, where children may be transported privately, was arbitrary. And it turned maintenance into a wealth transfer rather than reimbursement of the actual costs. That's the court's language. So translated into Kenyan, the court was basically saying, parenthood does not appoint one parent the ATM. Okay. Justice Namisi went further and stated that while a parent is free to relocate, the financial consequences of a unilateral relocation, that's a relocation that we didn't talk about, cannot automatically be imposed on the other parent, especially where both parents earn almost the same. And see, that's the standard this judgment sets. Okay? So let us be clear. The High Court did not remove physical custody from the mother. Okay. Also, it did not reduce the father's access as the mom wanted. It did not excuse the father from responsibility. Okay. What it did was to restore sanity. So what costs were shifted? The transport costs were shifted back to the parent whose relocation created them. That's the mom. Those quarterly clothing lists that were being sent were abolished. Each parent would clothe the parent while they were in their care. If the child is with you, you can clothe them. So payments for fees and uniforms were to be made directly where possible. So custody stayed, access stayed, responsibility stayed, but what changed was fairness. And this case quietly kills several Kenyan myths. That tender years automatically wins custody. No. That relocation has no consequences. That shared parental responsibility means one parent pays and the other decides. So Justice Helene Namisi reminded us that parental responsibility is not punishment, it's not leverage, and it's not a wealth transfer. It's about children not winning, okay? Anyway, if you enjoy this kind of breakdown, subscribe to the channel, because every week we take a real Kenyan case and explain it and say what it actually means without fear of laugh. Share this with someone who thinks that custody and maintenance or school transport is a personality trait. Anyway, and also, if you're watching this from Kilimani, especially if you're one of those people wealth people see and your partner helps people sleep, please talk about school transport early. Nikubaya huko nje, nikubaya. This has been Katiba na chai.